Today we have Mr. Douglas Pinkham, Managing Partner with Pinkham & Associates. We have received several questions online regarding family law. How are assets and debts usually divided in the divorce process?
Generally speaking, any property that you acquire after the date of marriage and before the date of separation is presumed to be community property. Now, there are arguments that some property or other property that you've obtained during that period is not community property. I'll give you a perfect example. If you inherit property from your parents or from a friend, that property, so long as you were the sole inheritor of that property, that's separate property. If your spouse or a friend or a family member gives you a gift, that is separate property. But generally speaking, anything that you acquire during the marriage, from the date of marriage to the date of separation, is presumed to be community property. That is also true for debt. Any debt that you acquire, either alone or jointly with your spouse during the marriage, which is from the date of marriage to the date of separation, is presumed to be community debt. Now, upon divorce, community debt and community property is generally divided 50-50. One exception to that is, let's say, for example, one party earns a tremendous amount of money. Let's say they earn $200,000–$300,000 a year, and the other parent is a stay-at-home parent. The court is not likely to divide $60,000 or $70,000 worth of credit card debt equally and give a non-working parent, a parent with no income, $35,000 worth of debt. That's not likely to happen. So what can happen? The parent that earns the greater majority of the income, that person might acquire more of the debt and more assets to make up for that debt that they may end up assuming. That's just one way to handle this, but that gives you an idea of how we divide community debt and community assets in a divorce.